Report from Santa Fe is made possible in part by grants from the members of the National Education Association of New Mexico, an organization of professionals who believe that investing in public education is an investment in our state's economic future, and by a grant from the Healy Foundation, Taos, New Mexico.
Hello, I'm Lorene Mills, and welcome to Report from Santa Fe. Our guest today is the Chief Justice of the New Mexico Supreme Court, Charles Daniels. Thank you for joining us.
Thank you, Lorene, for letting me be here.
Well, I'm so excited to talk with you about the constitutional amendment, SJR 1, that's going to be on the ballot this November for everyone to vote on. So, what you've done in this amendment is to take a money-based bail system where anyone can buy their way out to an evidence or risk-based system where a judge would have the opportunity to discriminate who is really a danger to the society and who is harmless and can afford to be released from jail. Tell me about it.
In other words, from a system that decides who gets out of jail and who stays in jail before their trial based on how much money they can pay a bondsman, regardless of whether they're high risk or low risk, to one that's based on an assessment of the individual risk. Is this person dangerous? Is this person likely to flee or is not a risk? And so we want to get away from making the separation between the people who are released pending trial and the ones who are held at taxpayer expense in jail pending trial be based on something other than how much money they or their friends can come up with.
And this is, some people say, well, this is a no-brainer because we've had the most heinous criminals who were given the money or had the money to buy their way out of jail when somebody with a bounced check and a traffic ticket can't afford the fees and the fines, and they're staying in jail at great expense to the counties and the county jails where they're held.
Anybody who looks at this and looks at the reality of what's going on will support this unless they have a personal financial stake in the current dysfunctional system. The only significant opposition to this is coming from people who are making money by dangerous people being released or by pressures put on family and friends of people in jail who shouldn't be there.
Well, thank you for helping me when I was struggling because it is wealth-based versus risk-based. And what has happened in the past is that if a defendant, no matter what he did, has the money, he can buy his way out. And so the people that are affected by this, there is, in this country, a very lucrative bail bonding industry. And so they don't want this to change. But you point out, you've spoken before about it's very hard to change things in America. There's a lot of inertia. Both the system, the lawyers, the defendants, the population are kind of used to it being like this. But it doesn't have to be like this. And you call forth for us to have fresh eyes and to be intellectually honest and look at, is this working for us? Is it?
It's not working for us now. It can work better for us. And it's actually not something that we invented in New Mexico as a new way of looking at things. It's part of a national movement. There have been several states that have reformed their antiquated bail laws, the old money system, and have put much more sensible systems into place. And there are a lot of other states that are looking at it. I get calls almost every day from courts and attorney generals around the state, the United States, to find out about our experience here, just as I called on other places to find out what they were doing when we were trying to figure out what we could do to make New Mexico system better.
And wasn't what we did unusual in that it was a combination of private sector and public sector, and people kind of brought their best ideas? And although it altered, it came up in the House and the Senate, it was voted and amended and back and forth a little, but a lot of people participated in trying to craft a system that would work and that would be a vast improvement.
It was an amazingly broad-based collection of community interests that came together to support this, and the net result was something that you, as an experienced political observer, would agree is unusual, and that is that this resolution passed our New Mexico legislature by a unanimous vote of the House of Representatives, all Republicans and all Democrats, and a unanimous vote of the Senate, all Republicans and all Democrats. There wasn't a single dissenting vote. But of course, since it's a constitutional amendment, it has to be placed before the ultimate power in a democracy, and that is the people. So that's why it's on the November ballot.
So you've printed up this lovely flyer, and it's called Here is Justice, and it's bail reform on the 2016 November ballot. So that's coming up this election, and it's called SJR1, Senate Joint Resolution 1. Now, so people will see it on the ballot. It's a long ballot. They'll, we want it's at the end of the ballot, right?
It'll be toward the end of the ballot, but it may be last but not least. It is very important. I am absolutely convinced that in all my years on the court, and I'm nearing the end of my 9th year now.
The Supreme Court, you had 38 years before that, didn't you?
Well, 38 years in the law.
In the law,
in the courtroom and in the classroom as a professor. But I've been on the Supreme Court almost 9 years, which has been a wonderful opportunity. And there are all kinds of ways to do justice in this job at the top of the New Mexico judicial system, but there is nothing that I've ever done and that I think I will ever do on the court that has as much potential for improving our justice system as the passage of this constitutional amendment on this November ballot.
So, what percentage does it have to pass by?
It has to be passed by a majority.
Okay, just a majority, 51%
Yes.
or 50 point.
Right.
Yeah. So one of the things that has accelerated this is that our state is in a rather uncomfortable financial position, and we're having to have a special session and do a lot of things to deal with the shortfall that we have. And there's a financial side to this in that the county jails are having to spend a huge amount of money to keep nonviolent prisoners in jail because they can't afford the fees and the fines. I think for Bernalillo County, they spend about $60,000 a day. These are rough figures, housing at least 500 inmates that can't make bond. $60,000 a day in this financial climate is really worth looking at.
And a lot of them have been low-risk defendants, people who don't pose a risk to the public, while more dangerous people have been able to get out by coming up with money. And when we talk about the counties having to undergo this expense, we have to remember the counties are us, citizens, taxpayers. We're expending enormous amounts of taxpayer dollars guarding and housing and feeding and medicating and otherwise jailing people who don't need to be there. There are some people who need to be in jail because they're too dangerous to risk out on the streets. And that's why part of this constitutional amendment is to allow judges, based on the evidence, to make a decision that a dangerous defendant is just too dangerous to be released on the public after a due process hearing where the judge looks at the evidence of that. And for those people, we need the jail space, and as citizens, we need to pay to jail those. But we don't need to jail the people who are in jail only because they're poor.
Yeah.
It's a great detriment to them, their families. It causes loss of jobs, loss of homes, families to break up, families to go on public assistance. And if it's a dangerous person, so be it. But if there are people who don't need to be there, who are just there because they don't have the money to pay for a bond, it makes no sense at all then to have the taxpayers do that. One of the county officials mentioned to me that it would make more sense sometimes for the county government to just go hire bail bondsmen for a lot of these low-risk people because they're in jail often for not being able to come up with $100, $200, $500, and it costs our taxpayers $100 a day to keep them in jail. It would be cheaper for the taxpayers just to go buy a $1,000 bond and get the person out and save money in the long run. At least those persons were not at risk.
So one of the categories that you would put this is pre-trial justice reform. We were operating on, well, let's do some definitions now. You are a member of the judiciary branch of the government. there are three branches of the government: executive, legislative, and judiciary. Can you talk to me a little about how the judiciary stands? It's supposed to be separate but equal branch of government, right?
Sure. They're separate branches that work in a check and balance system and work in cooperation together as much as possible, but also keep a check on each other. And we have different functions. The other two branches are called the political branches. They're the ones who decide which laws should be passed and can get into the political rough and tumble. The judicial branch doesn't have the power to make laws. It doesn't have the power to raise money, to decide whether to increase revenue. Those debates that are going on right now are something that we can't have a part of. Our job is to enforce the law, to make sure that the laws passed by the legislature and signed by the governor, to make sure the Constitution, promulgated by the people, are not just words on paper. Without a judicial system, they are just words on paper and totally meaningless. The judicial branch has to enforce those laws, decide disputes in a reasonable and peaceful way so we don't have the law of the jungle, to have a system of deciding who's guilty, who's innocent, who's going to get the child in a marital breakup, who is at fault in an automobile accident, so we handle it that way instead of with guns on the street and other kinds of unlawful methods. So our job basically is to enforce the law. There are a lot of people who think that we get to decide what the law should be, and that really is not our function. We try to avoid that. Sometimes where the law is vague, we have to interpret it, but we have to do that according to established principles. Sometimes there are policies that we have to decide where there are cracks in the law that we have to fill in and try to fill in those cracks consistently with the rest of the fabric of the law. But our main job is to apply and enforce the law rather than to make it, and put aside our own personal feelings. There are laws that we apply as judges that we would not have passed if we'd been legislators, but we have to respect the functions of the other branches of government because they serve the people in different ways than we do.
So when people get all nervous about a constitutional amendment, it is in the people's hands, it is the people's power. And when people look at an amendment like this and see how it will improve our system and make everyone safer and a little bit richer, not directly, but not having to pay to have all these people who can't bond out, then I would think that anybody who looks at this with a dispassionate gaze and that isn't financially involved would realize we have to give the judges the authority here to determine whether the person is a flight risk or a menace to society, and whether they're just too poor to do a $100 fine, and so we keep them in jail for months.
That's right. And people ought to be cautious about amending the Constitution. The Constitution is the basic contract between the people and the government they created. And the Constitution sets forth some limits on what our government can do because the people didn't want to surrender all their power to government officials. And so it's important to look carefully at amending the Constitution. The Constitution that was passed in 1912 when we became a state was a document that served the needs of that time. As judges, we can't say, well, we're in different times now, so we're just going to disregard it. There's an amendment process, and it's designed as part of the Constitution so that the people can look at changing needs. This provision in our state constitution now provides that all people, other than in certain narrow categories of capital cases, death penalty cases, all persons are entitled to be released on bond during pre-trial. The history of it is long. We don't even have a time to go back to the history, but the concept of bond went back to before the Norman conquest of England in 1066, back at a time they didn't have jails and capital punishment where somebody who committed a wrong against someone would have to pay money or goods to the family, and so they were entitled to be released from custody if they had somebody stand up for them and say, I'll stand good for that money. And then later, when it became an offense against the state to commit a crime against the king, we kept this money bond system. And it came over from England to the United States, not as a commercial bond system. That's a recent growth. But a system of having some neighbors stand up for you and say, I'll stand good for this. And the provision of our Constitution in New Mexico that provides an absolute right to bond came from a 1682 pre-Revolutionary War Pennsylvania Commonwealth Constitution that had that old language in there from a previous time. And a number of states just ended up adopting that language. New Mexico did when it became a state in 1912. We've gotten to be a much more complex society since then, and I think we've realized that there are some defendants who are too predictably dangerous, based on evidence that we have, to be released. If you have somebody who's had a history of violence, who's tried to kill his wife, and she's somehow surviving, and he tells the police when he's arrested, if I get out, I'm going to finish the job. We have someone like that, then it doesn't make sense to release them if they can just come up with a bail bond. That is something that maybe they didn't think about in 1682 in Pennsylvania, or even in 1912 when we adopted our Constitution. And so we have an opportunity in New Mexico to look at our current needs and our current society and decide whether there's a better way of doing things. And actually there are studies around the rest of the country that show there are much smarter ways of separating the people who should be detained from the people who do not need to be detained, to have a much more evidence-based system, risk-based system, rather than a money-based system.
Or a money-based system.
Yeah.
That's a fascinating history. I didn't realize how far back it actually went. We're speaking today with the Chief Justice of the New Mexico Supreme Court, Charles Daniels, and listening to you tell me about the history, because I learned a lot from that. How did you first get interested in law yourself?
I was reading a book, actually. I was pretty directionless when I got out of high school. I was the first person in the history of my family to even get to go to high school. And so the idea of getting into the law just never occurred to my brothers or myself. And I joined the military right out of high school and got stationed in the Arctic, up in the North Pole, radar station. It was the northernmost location of human beings on the face of the earth. And I started doing some reading up there, and I read a book about a famous American lawyer named Clarence Darrow, who fought for justice. And as I was reading about him going to court and fighting for principles that were important to him, I remember that just like the hair went up on the back of my neck, and I put the book down and I thought, I can do that. And so I ended up being stationed back in the United States in a job that had 24-hour shifts, and I volunteered to do straight midnight shifts on the base, and then I enrolled in the University of Arizona full-time as an undergraduate student, got my bachelor's degree by the time I got my discharge, and I was in law school 2 months later, and I've never looked back. It's been a wonderful opportunity to work in the cause of justice, and now I have a job where that's my job title.
Yeah, Chief Justice. Well, you excelled in law school. You were first in your class. You edited the Law Review, which is the really powerful job that needs a lot of discernment. So one of the things in your writings about this issue of bail reform, you do say we need to have the intellectual honesty to see what's really working in our pre-trial justice system, and then the moral courage to change it, to make changes if there's a way we can improve it. And you yourself said that nothing in your career accelerates the progress of justice than this does. And now the citizens of New Mexico, when they go to vote, have a chance to make this happen, to bring justice into the pretrial system, a better sense of justice, where it is, risk-based, not resource or wealth-based. So thank you. I just hope that, people, this has been a tough election cycle, and people, some of them at some point just don't want to hear anymore, but this affects all of us.
It affects all of us, and it should be beyond politics. When I came onto the court, I ended up changing my voter registration to be independent, to reflect in appearance what the change in reality was, that I had divorced myself from partisan politics in order to serve the justice system. And I'm not involved in the elections for president or legislature or any other political races. Like other judges, I no longer go to political events, don't get involved in things like that. But on matters relating to improvement of the administration of justice, we do stay involved because we know where the problems are, and it's our obligation to tell our fellow citizens what we've seen and what we know we can do better and how we can help them better. Because now often judges will get blamed because someone bonds out and then goes out and commits some horrible crime. And it's easy to blame the judge for that, but it doesn't do any good. It doesn't help anybody in the future. What we need to do is look at, how did this happen? And is there a rational and fair way to keep that from happening in the future? And this is a good example of that. A bail bond does not protect the community in the slightest. A bail bond cannot be forfeited for commission of a new crime. It can only be forfeited for failure to appear. And so the person who says, if I get out, I'm going to go ahead and finish killing my wife, neither that defendant nor the bail bondsman stands to lose a penny for commission of that new crime. It makes no difference to that crime victim whether the person who committed the crime on him or her was out on a $5 bond or a $5 million bond. One of the problems with our current constitutional provision is that it doesn't give the judges the honest authority to say to a defendant, this evidence shows you are too dangerous to risk out on our streets. It doesn't allow that honest authority. All it does is say that a defendant has a right to be released pre-trial on bail, and then the judge can set a dollar amount, which by the law that's been handed down to us by the United States Supreme Court, which is above our court, is only intended to ensure the defendant comes back to court after he's released. That's what the bond is, put something at stake on the table. And so judges are supposed to set an amount of bond if they think it is necessary to get the defendant to come back to court. There are actually a lot of ways to get people back to court other than paying for a bail bond, but that's the theory of it. And so what judges do without the honest authority to deny release to someone that they know is going to endanger their communities is they will set an amount of bond that's not designed to get the defendant back, but that's designed to deny him his right to release in the first place. If you see accounts of a judge setting $1 million bond in virtually every case, that's not to get the defendant back. That's to try to kind of find a figure that will deny him his constitutional right. And even though that's really an unlawful exercise of the bail-setting power, you have to understand that the judges who are doing that, even though we can admonish them, the Constitution says you're not supposed to do that, they're doing it because they're faced with a choice that no judge should ever be faced with in our society. They're faced with a choice of honoring their oath of office and allowing the person to be released on bond, even though they know they're going to endanger the community, or choosing to violate that oath of office and try to protect the community by doing something unlawful, setting an amount of bond that's not designed to get them back, but that's designed to deny them a right to release in the first place. No judge should ever be put into that position, and it doesn't work. It's like a drift net where you're trying to catch a shark, and some of the sharks get through. the people who can come up with money, or whose friends on the street can come up with money, or who can work out a payment plan with a bail bondsman, often get out and commit these horrible crimes. And that net catches a lot of these little fish that never should have been caught in the first place, the people who are not a risk to any of us.
So what this does, on the November ballot, our citizens of New Mexico have a chance to take that burden off of the judges, where they have to violate their oath of office because they know that this person is dangerous. This gives them permission then, to be sure that I'm saying this right, to use his own judgment then, how dangerous the defendant is, and whether it's small potatoes, there's no danger to the community, the person will probably come back. So what this is doing is letting the judges do their job better.
It's letting them do their job better and more honestly, and much more effectively, because under this amendment, there's a due procedure built into it. The new language in the Constitution would provide that a judge can deny release if the judge finds by clear and convincing evidence that the defendant would be a danger if released. So there's a process put in there that will amplify with our court rules, where there's a hearing, where the judge looks at evidence instead of just pulls a figure out of the air, and looks at evidence and makes a finding on the record as to whether the defendant is dangerous or not and why, and then an expedited appeal procedure. So it provides due process for the defendant, but it also provides protection for the community in an area that's now without all those tools, where the judge, like the workman whose only tool is a hammer, who treats every problem like a nail.
Yeah.
Our judges now just have this money setting provision, and ultimately the judge doesn't decide who gets out. That a bail bondsman decides who gets out.
Yeah.
If the bail bondsman decides to write the bond, the defendant gets out. And if the bail bondsman decides not to, the defendant doesn't get out. The judge has the fairly insignificant job of just putting the price tag on somebody's presumption of innocence.
Well, we're going to have to leave it there because we've run out of time, but you did nail it. What we want people to know, that this goes from evidence-based bail setting to, instead of wealth-based, that people cannot buy their way out of jail. In other words, the get out of jail free card. Our guest today is the Chief Justice of the New Mexico Supreme Court, Charles Daniels. Thank you for explaining this to us, and just we'll speak with you after the election. We'll see how we do.
Thank you, Lorene, and thank you for the service you provide to the people of our state.
And I'm Lorene Mills. I'd like to thank you, our audience, for being with us today on Report from Santa Fe. We'll see you next week.
Report from Santa Fe is made possible in part by grants from the members of the National Education Association of New Mexico, an organization of professionals who believe that investing in public education is an investment in our state's economic future, and by a grant from the Healy Foundation, Taos, New Mexico.